This is a ruling resulting from an application brought under Section 5 of the Human Rights Enforcement Act, Cap 12, on the enforcement of rights and freedoms by magistrates' courts among the prior suit. At that, the court exercises its jurisdiction to stay proceedings in criminal case number 624 of 2022, orders for cessation and continued unlawful detention of A1, Dr. Colonel Kizza Besigye, order authorities to seize the unlawful detention of A1, Dr. Kizza Besigye. The law relied upon is the Constitution, 1995 Republic of Uganda, the Human Rights Enforcement Act, 2019, the Judicature, Fundamental and Other Human Rights and Freedoms Enforcement Procedure Rules, instrument number 21 of 2019. As per Article 50 of the Constitution, provides that any person who claims that a fundamental or other right of freedom guaranteed under this Constitution has been infringed or threatened is entitled to apply to a competent court for redress, which may include compensation. Clause 2, any person or organization may bring an action against the violation of another person's or group's human rights. Any person aggrieved by any decision of the court may appeal to the appropriate court. Parliament shall make laws for enforcement of the rights and freedoms under this chapter. Refer to the case of the Kenya Church Ambrose versus Attorney General, which is a constitutional appeal number 3 of 2011 on the legality of Article 51 and 54 of the Constitution. Jurisdiction. Human rights can be enforced by the High Court or a magistrate's court, which under the Human Rights Enforcement Act of 2019 are referred to as the competent courts. Section 4 of that act is to the effect that the High Court shall hear and determine any application relating to the enforcement or violation of A, non-derogable rights and freedoms guaranteed in Article 44 of the Constitution, B, other rights, duties, declarations, and guarantees relating to fundamental and other human rights and freedoms envisaged in Article 45 of the Constitution. Rights and freedoms restricted under a law made for purposes of a state of emergency, and D, rights and freedoms preserved by this act to be determined by a magistrate's court, where the remedy sought by the applicant is beyond the pecuniary jurisdiction of that court. Under subsection 2, applications under this subsection 1 shall be in the form prescribed by regulation and may, unless the High Court determine otherwise, be heard in open court. On the other hand, section 5 of that same act states that a magistrate's court shall hear and determine applications relating to enforcement or violation of human rights and freedoms guaranteed in Chapter 4 of the Constitution in any of the circumstances not referred to in subsection 1 of section 4. Under section 6 of the Human Rights Enforcement Act, a suit for the enforcement of human rights should be, where possible, lodged and instituted in the court in whose jurisdiction the alleged violation took place. Human rights matters can also be referred to the High Court, where they arise in proceedings in a magistrate's court, as referred to in section 7. They could also arise in proceedings in the High Court, in which case the court may stay proceedings and determine the human rights enforcement matters as per section 8. Refer to the case of Mukaku and 12 others versus Aglis Ranch, 20 and 21 Limited, and 3 others. It's a miscellaneous cause number 11 of 2020 for human rights actions of a public interest nature that have to be filed in the Constitutional Court. Accordingly, in the case of Mukaku, a case in public interest has to be instituted in the Constitutional Court. Local standard. It's important to note that the right to apply local standards is not only restricted to the person whose rights have been infringed or threatened, but can be brought by any other person. See Article 50, Clause 2 of the Constitution. Section 2 of the Human Rights Enforcement Act, 2019, defines victim of human rights violation to mean a person who suffers a human rights violation and includes the person's immediate family or dependents or any other person whose rights have been violated as a result of the violation of the victim's rights and freedoms. Section 3 of that act states that in accordance with Article 50 of the Constitution, a person or organization who claims that a fundamental or other right or freedom guaranteed under the Constitution has been infringed or threatened may, without prejudice to any other action with respect to the same matter that is lawfully available, apply for redress to a competent court in accordance with this act. Under Rule 6 of the Judicature, Fundamental and Other Human Rights and Freedoms Enforcement Procedure, Rules, Instrument number 21 of 2019, the persons who may bring an action to court for redress are a person acting in his or her own interest, a person acting in the interest of another person, a person acting as a member of or in the interest of a group of or class of persons, a person acting in the public interest, or an association or organization acting in the interest of its members. As per that instrument, an action for enforcement of fundamental and other human rights and freedoms can be brought against any person, government, organization. Under Section 10 of the Act, public officers may be individually held liable for human rights breaches. This means that a particular public officer could be made a co-respondent to the action. That Act also goes ahead to explain the procedure, and among the remedies in that Act or reliefs, under Section 9 of the Human Rights Enforcement Act, court is empowered to issue appropriate orders, including compensation. Under subsection 2, the competent court may, in addition to the orders referred to under subsection 1, order 4, restitution of the victim to the original situation before the violation of his or her human rights and freedoms, rehabilitation of the victim, including provision of medical and psychological care or satisfaction, which shall include measures aimed at the cessation of the continuing violation of human rights and freedoms, verification of facts, full and public disclosure of the truth to the extent that such disclosure does not cause further harm or threaten the safety and interests of the victim's relatives, witnesses, or persons who have intervened to assist the victim or prevent the occurrence of further violations. Under subsection 3, restitution, compensation, rehabilitation, or any payment ordered by the competent court under this section shall be a civil debt owed to the victim of human rights violations. The court, in addition, may takes into consideration the need to redress a public injury or the need to enforce a public duty. Now, with specific regard to the application before this court, the court takes judicial notice of the fact that several similar applications have been made and are pending before the Civil Division of the High Court. One such application is High Court's miscellaneous application number 0031 of 2025, retired Colonel Dr. Kizza Besigye and Haji Obed Otale versus the Attorney General and Commissioner General of Prisons. An application for orders that are writ of habeas corpus and sub isidem be issued, ordering or requiring respondents to produce the applicants before the High Court for appropriate orders. This application in the High Court has similar effects as the one before me. When two similar applications are made in both the Magistrates Court and the High Court under the Human Rights Enforcement Act, the following scenarios may occur. The first is jurisdiction. The High Court has broader jurisdiction and can handle more complex cases, including those involving non-derogable rights and freedoms guaranteed under Article 44 of the Constitution. The applications being similar before both courts, the High Court takes precedence. This also serves to avoid duplication of efforts and conflicting judgments. It ensures a more efficient legal process and consistent rulings. With that being the case, court strongly points out in coming to a decision the following. Dr. Kizza Besigye was granted bail in this particular matter on the 1st of July 2022 and has since been exercising his right to liberty. Secondly, the human rights violations raised were not committed within this court and or within its jurisdiction. An application whose decision has a similar effect as the one before this court, which is High Court MC number 0031 of 2025, retired Colonel Dr. Kizza Besigye and Haji Obed Otale versus Attorney General and Commissioner of Prisons is before the High Court and is being determined. The High Court takes precedence over the Chief Magistrates Court of Buganda Road. A decision by this court on prayers made has the effect of creating parallel proceedings and the potential for conflicting decisions and judgments, which curtails judicial efficiency. The application made by defense counsel in this court is hereby dismissed, the same having been improperly made before this court. The court, however, through its inherent powers conferred under Section 98 of the Judicature Act, stays proceedings in criminal case number 624 of 2022, and the rationale for this is here: to allow the human rights issues raised to be determined in the application before the High Court. Dr. Kizza Besigye, given his current health, is unstable and therefore unfit to stand trial at the moment. A stay of these proceedings is the most logical remedy to allow him to restore his health. to normalcy. Proceedings are temporarily stayed for a period of 60 days. Since A1 is a public figure, criminal summons shall be issued when A1 is deemed fit to stand trial and a hearing date shall be fixed. In the interim, his bail is extended till such time.